Well, thank you very much to everybody who came. I know that we had a lot of registrants who would like to see a recorded version of this, so we are recording it now. It's my great pleasure to introduce Tom, who's here today from Bon Bryson to talk to us about rep contracts demystified. I know that he's going to introduce himself in a lot more detail, but a lot of thanks to Tom. Just take it away.
Thank you, Laura. Can you hear me okay?
Yes, definitely.
Oh, good. Okay, yeah, I'll go ahead and proceed. So as Laura said, I'm Tom Camerite from Bon Bryson. I'm a rep attorney, among other things, worked a lot on the rep side and the principal or suppliers in these contracts frequently from both sides. I'm a little nuts. I actually maintain a library of these contracts. I have about 200 of them I've accumulated over the last 20 years. So lots of experience here with different clauses and the impact of that. And as you might expect, we frequently got involved in commission collection cases. That's the outcome of a rep contract doesn't go well. And of course, today we want to work on putting together the elements of a contract in such a fashion that things would work out well, both for the supplier or the principal, and then also for the rep. So a little bit of an overview. First of all, just to walk through that, we'll talk a little bit about disclaimers. Today's presentation is information. And again, I want to thank Ryan and Laura for the opportunity to present today. But again, this is information only. It's not legal advice. It's very important that you check with the rules and laws and your advisors in your own jurisdictions. Talk a little bit about the parties. That's important from a risk management standpoint. The actual appointment of reps. Reps have a duty of loyalty to their principals or their manufacturers, as do the manufacturers have a duty of loyalty and reasonableness back to the rep. Territory is also an important consideration. What became fashionable about 10, 15 years ago is to break territories into account-by-account bases. We still have lots and lots of geographic territories out there, but there's a lot of opportunity that can come from account-by-account territory designations. Products and services, again, another important provision to have that properly defined in your agreements. Commissions, that's probably one of the most important provisions. How exactly do they arise? How are they earned? How are we going to compute them? Sometimes when reps are getting started in a particular territory, some sort of stipend or market development fee is negotiated. We'll talk about those a little bit too. Acceptance of orders, that's a big deal in the contract world between reps and their suppliers or their principals. Typically the principal has the authority to accept, and typically the agent or the rep does not. Terms of sale, we'll also touch on those. Talk a little bit too about the essence of the rep relationship and how business should be conducted under these agreements. Probably the most important provision in any rep contract is a term or termination provision, so we'll touch on those. And especially important is the set of rights that the rep might have and the responsibilities that the manufacturer or principal might have upon termination. And then finally, we'll talk about things that are referred to as boilerplate. That's simply a legal term for stuff that's at the end of the agreement, but a lot of these provisions make a lot of sense, and it's worth walking and talking through those as well. And feel free to organize your questions as you go along. I think there's a way for you to send those to us by email, and we'll answer those at the end of the presentation as well. So first on the disclaimers, again, just to emphasize, this is informational only. These are about 10 to 12 important elements that turn up in almost any rep and principal or supplier relationship. Good idea to cover those items. If you don't, problems might ensue. There are cases where some of these provisions can be skipped or glossed over, but for the most part, these are important elements of a rep contract. Our goal here is to give you a useful guide to be able to put together a rep contract or review one critically. And again, just want to emphasize to consult with your local advisors and the laws and rules of your jurisdiction as well. True value of reps, I'm going to go strategic here for just a minute. It took me until the last 5, 10 years really to learn or understand this. The true value of a rep, in my mind or from my experience, is their knowledge and relationships with the customers. They built a channel, some sort of piece of connectivity, so it's very easy for them to get to the underlying customer, and it might be very difficult for the principal, the supplier, the distributor, the dealer, the manufacturer to jump into that same relationship. This value usually been accumulated over years and through experience. Credibility has been built up over time, and so this is where reps can have a lot of value in the marketplace, and it's that knowledge and set of relationships, both of the customers, the territory, and also the industry, that can be very helpful and make a rep very, very valuable. As I had indicated before, and just for emphasis, the termination provisions in any rep agreement are primary. They're very, very important. And I would just say there's a loose symmetry between the amount of time a rep signs on, learns the territory or product, is out there trying to sell or promote that particular product, a sale is actually accomplished, and then product is shipped. In many industries, this might be 2 or 3 months. In other industries with capital equipment or longer, more intensive or broad sales, this might be 6 to 12 months or longer. And I would just say from a mutuality and symmetry provision, we want the contract term and the post-termination commission provisions to generally be in alignment. If they're not, we've got situations where a rep might be providing value and unfortunately not necessarily being paid for that. That can be accomplished potentially contractually. Most reps, of course, would be frustrated with this, and most principals might in that situation receive some sort of windfall. So we're always looking for fairness. I'll just say straight out, I'm not necessarily looking for termination provisions that might exceed the length of time it took a rep to produce a particular set of sales, but I'm not looking for them to short the rep either. Reps have very strong legal arguments to say, hey, wait a minute here. I put in the time, I built the relationship, I had the pre-existing relationship with the customer, but for me, this order wouldn't have been developed. And I do think out of a sense of fairness, in most instances, then the commission can be paid. And typically the disputes are over unpaid commissions. Most laws in most jurisdictions are going to be pretty protective of reps. In many instances, there's double damages plus potentially legal fees for that. And it's all about timing, and we'll dig into that a little bit more during the presentation as well. And the timing considerations are exactly when is a commission earned, and when is the product shipped, and when does that obligation for payment on behalf of the principal arise. And it is important to attempt to address that in any good rep agreement. Onto the parties. This is really primarily for the protection of both sides. Almost all suppliers or principals are going to be incorporated. I think that's essentially a given. We frequently still run into situations where the rep isn't necessarily incorporated, and I would say all day long, both for the supplier's protection and for the rep's protection, the rep ought to be incorporated. In most jurisdictions now, it's not too difficult to set up some sort of organization, limited liability company. What we're trying to do is set up a corporate wall of protection for the rep. We really don't want the rep to have product liability with respect to anything it's selling, and this is a good way to try to limit that liability just to the assets of the agency, which tend to be fairly modest, rather than opening up all of the rep's assets to that kind of exposure. The other thing is, from a manufacturing or supply perspective, to the extent the rep is not incorporated, there might be a whole set of employment laws for both the rep and the principal or the supplier here to have to comply with. And so working from company to company is just a little bit smoother, and in my experience, that's probably 85 to 95% of the time in a rep and principal relationship. Here too, we might be looking for indemnification. Typically, we look for those provisions to be mutual. The rep will indemnify the manufacturer for, let's see, bad or negligent things it might have done. But in that situation, we're going to look for mutuality from the supplier or the principal here too, to say, look, we'll indemnify you for product liability, those other things. Again, from a risk management standpoint, it's good to have our interests aligned and have those indemnification provisions be mutual, with each side reimbursing the other for its own mistakes or problems that it might have generated. Appointment and acceptance of reps. Usually what's entailed in these provisions is a description of the rep's duties. My theory here, or strategy, would be from experience that a rep really has an obligation to promote, solicit, expedite, drum, do all of the things necessary to generate an order. They do have a duty of loyalty, and this spans across jurisdictions. Doesn't matter if we're working in the UK or France or South America or United States or really anywhere worldwide. You are an agent of the principal or the supplier here, and so then there's a duty of loyalty. Now, that can be managed by contract or otherwise, but there's a duty of loyalty and good faith there. Similarly, the principal or the supplier has a list of duties of loyalty as well. There's duties under most jurisdictions to act reasonably with respect to the reps. if the rep relied on a representation from the principal to go out and sell some product, then if they were involved in the generation of that product sale, I would say most judges and most jurisdictions would say the rep ought to get paid there. Sometimes principals will negotiate exclusive versus non-exclusive agency deals. Because of this proliferation of account-by-account basis, it's entirely possible for one rep to be in a territory and be selling, for example, to the food products industry, and another rep to be in the same territory and be selling to the plastics industry. So it's okay to do that. It helps the principal really fill up its coverage of a particular territory, and it leaves each rep free to specialize in the kinds of sales that they're doing. Another important theoretical thing for risk management purposes is that the rep is typically not accepting an order. They're doing everything he or she can to generate an order, but acceptance typically is back at the home office or back at the principal, the supplier, the manufacturer, whoever that might be. In this manner, then, the rep is not in the chain of title, and it just makes it a lot easier to deal with products liability and other kinds of defensive type claims in case there is some sort of product. Let's say this is a medical product, and occasionally there are some human or personal injury risk that comes from that. This, for the most part, will insulate the rep from that unless they're involved in some sort of overt or negligent activity. So appointment and acceptance are important, and a clear understanding of both sides' duties makes a lot of sense, as well too. And then territory, talked about that, and I just want to expand on that a little bit. For the most part, and I think historically, territories are geographic. They might be by county or parish or state or country, but do recall or remember that it's gotten very common to have account by account or industry by industry territories as well. So it's important to define those clearly so both the supplier and the principal and the rep, all of them know and understand exactly what responsibilities the rep have within that territory. And again, whether it's by customer, industry, or there may be other ways to cut up that territory and get a proper focus in that particular situation. Products and services, a lot of times what's listed here is certain products by product number or otherwise that might be excluded from the rep's activities. That's okay. The principal or manufacturer might have a direct access to those particular customers or a long-standing relationship, and so the rep's functions are deemed really not to be necessary in that particular instance. But it is all about defining exactly what those product divisions and product families are, and again, it might get down to part number designations on those particular situations as well. Sometimes there are other exclusions. There might be exclusions for competitive or other kinds of reasons. And again, generally an agent or a rep would have a duty of loyalty to its manufacturer, but it's good to lay that out specifically. Frequently, reps are involved in selling on behalf of complementary products to the underlying principal or manufacturer, not necessarily competitive, but these are products that might work in tandem. But it's good to lay out in the agreement or otherwise that this is not necessarily a competitive product. In fact, many times a principal or a supplier wants to be seeing its product being sold in tandem or in unison with another set of product. And again, it's all about laying those out properly so both sides can convey the most value to each other under these agreements. Commissions, again, just want to talk about that a little bit. It's all about what exactly under the rep agreement is a commissionable order. There are all sorts of variations you'll find in contract land or contract world over how exactly commissions are earned, but the general one I see that gets gravitated toward is this issue that a commission is earned on shipment. So just to talk through a time frame, the rep might spend a month or two introducing himself or herself and its principal or manufacturer to the underlying customer. There might be a time frame for specifying or engineering what goes into the orders and how much that will take. Hopefully what we're all looking forward is what's called a PO or a purchase order. On that purchase order will be some sort of ability by response from the principal or the supplier here to go ahead and accept that order. And again, recall that the rep here is not going to be involved in the acceptance. The principal is going to be involved in that acceptance. Then the principal goes about drawing on that order or manufacturing it and then actually shipping it, hopefully within 4 to 6 weeks, sooner or later thereafter. It's at that very point, from an accounting perspective, a rep perspective, a manufacturer's or principal's perspective, we've had a set of activities, the rep's activities and the supplier's activities or the principal's activities, and now we're set to say, hey, wait a minute here, there's $100,000 being shipped on Tuesday, now we're going to have a commission that's associated with that. Typically, the commission is payable once the manufacturer is paid. I typically see payments where these payments happen, let's say 10 to 15 days after the manufacturer is paid, as an example. Sometimes the manufacturer pays on an accrual basis, meaning they'll pay within a time function, say 30 days from shipping something on that order. All of these things should be negotiated in the contract so both parties understand how the rep will be paid. There are a number of adjustments to commissions, with the advent, and it's happened down a lot now, but the wild fluctuation we had in commodity prices the last couple of years led both principal and rep to do some sort of allocation or carve out of, let's say, steel or oil that might have been a component to the product that's being sold. So there might be some adjustments. The point is here, should the rep really share in a wild fluctuation up or down in terms of a commodity price? And I think both sides would generally say no. Also, sometimes there's exceptions or exclusions for freight or tooling charges because it's really not a direct relationship to the product or the value of what the rep is selling. So do be aware of those and make sure that the contract spells those out clearly as well too. Talked about this a little bit at the outset. Frequently, a territory might be new to the rep or it might be new to the supplier or the principal. And so there are times at which the supplier here, the principal, might want to support 3 to 6 months, let's say on average, of pioneering type work in a particular territory. There are different names for this. It might be called a pioneering fee, might be a market development fee or management fee, territory management fee, stipend. All of those things are out there to say, hey, we're going to support the rep who's fairly new in this territory or new in this industry and see what happens. Typically, there is some reporting back and forth in terms of the information and the prospects that the rep is generating. And again, in my experience, I usually see the fee lasting something on the order of 3 to 6 months. It's not unusual at all to say, well, wait a minute here, we've been supporting you in the marketplace at the rate of $3,000 a month or some other figure for a number of months. Now we're going to use that as an adjustment against the future commissions that are owed. And again, all of these terms are negotiable, but things to think about both by the supplier, the principal, and the rep, if they're going about embarking on a territory that's relatively new, or an industry or a country, let's say, that's relatively new for the supplier or the principal here. Terms of sale, this was this issue all day long where it's the supplier or the principal that's making the terms of sale and setting them out. I do believe it's the rep's responsibility to understand what those terms of sale are, pass that knowledge and information on to the underlying customer. But again, the rep is not involved in acceptance. The manufacturer wants that because it wants to pick and choose and select what orders are appropriate to it, and obviously the rep is going to be very knowledgeable when it comes to that situation. The rep really does not want to be involved generally, I would say, in acceptance because now there's liability and responsibility for that actual acceptance. So typically that authority is retained by the principal and not passed on or delegated to the rep. And then the pure essence of the relationship here is the rep is really generally an independent contractor. It's, again, good to set this out so we don't have employment issues cropping up both for the principal and for the rep. Just because the contract says that a rep is an independent contractor doesn't necessarily make it so. Most jurisdictions will look through the contract and say, hey, wait a minute here, what really are the functions and duties? Generally, to the extent a manufacturer or a supplier or a principal controls in great detail what the rep is doing, you're going to head into potentially a rep relationship, or I'm sorry, an employment relationship. And generally, both parties aren't looking for an employment relationship. This is one of the reasons to set up a separate corporation, again, in most jurisdictions. One of the things that secures the fact that there's not an employment relationship is if the rep has other relationships with complementary suppliers, let's say one way or another. To the extent there were 2, 3, 4 of those, it's very hard for any government to argue that there's an employment relationship. The rep really has then sustainability, its own viable business, and it's in a situation then where we don't have to run afoul of some of the employment rules and regulations. As far as conduct of business, want to just touch on some things here too. One of the great, I think, foundations to all of these contracts is a set of mutuality. So we're back on indemnification and just want to expand that a little bit. The manufacturer here, a supplier, the principal, the dealer might either have access to a product or manufacture or create a product that's got some risk associated with it. Typically from an insurance and product liability standpoint, the manufacturer would take on that risk. Similarly, the manufacturer would then, or supplier and principal, would indemnify the rep if something went wrong that was the supplier's or the principal's fault. Similarly here, though, too, let's say the rep did something very wrong. They intentionally misapplied a product to the wrong situation, creating some risk to individuals one way or another. Here, too, a mutuality indemnification provision would say is no, in that situation, the rep's actually going to indemnify the supplier or the principal here for the risk that it might have created. And as long as everybody's careful on both sides, this should work out just fine. For both parties' protection, good people are getting to be in short supply worldwide, and so it's very typical to see a non-solicit provision. This means the manufacturer can't raid or go hire employees from the agency of the rep, and similarly, the rep can't go hire employees from the supplier or the principal here without the approval of either side. And it is a good idea to the extent you can, and sometimes it's difficult or it's costly, but it's always worth investigating insurance on both sides. Typically, there are some general liability coverage provisions that the supplier or the principal might have in place, and it's not too difficult to add the rep as a named insured in that situation. And again, just trying to provide some good insurance coverage for all of the parties involved, so they are protected as they go about their business efforts. Term and termination. This is one of the most important, if not the most important provision of this contract or these types of contracts. Typically, we see termination provisions first having some sort of notice period. Hey, if we're going to terminate this agreement, there's a 30, 60, 90-day notice period. And then typically there is a post-termination commission payment period that, again, should be aligned with the rep's efforts, the opportunities or customer situations that they worked on to pay them fairly. To the extent the manufacturer doesn't want to pay a rep fairly, they're likely to run afoul of local legislation that supports reps being paid. And reps, to me, should be paid for the opportunities they generate, and of course should not be paid for the ones they did not generate. How we separate that out is important to address in a contract, typically done by time frames and relate to certain industries. Very frequently under many industries, there might be a 30, 60, 90-day notice provision again, followed by a 3 to 6 month post-termination provision. If someone's involved in a very, very long-term sale, it takes a year or two to build the relationships inside the customer, teach their engineers about the product, get the product spec'd in, get subject to a purchase order of some significant size. In those situations, you might see much longer termination provisions. And another one might be there might be a 3 or 4 year buying cycle in certain industries. For example, anything having to do with trucks or auto, motor type designs. Tooling may not change for 3 to 4 years. So once a rep generates an order, it might very well generate commissions under some of these provisions for 3 or 4 years thereafter. There typically is a duty of loyalty for the rep back to the supplier or the principal in those situations. The concept is, hey, I'm still being paid a commission here. I should be loyal to that rep. I'm not necessarily going to try and change or compete there. And I think, again, that's a fairness thing to be negotiated between both sides. But from my perspective, it's fair as long as the supplier here, the principal, is paying commissions, that the rep retain its duty here too. And it's all about alignment of interests. Once interests are not aligned, that's likely where we might see some friction. A quick example would be is a supplier or principal has a 30-day notice provision, but it takes 3 to 5 months to generate a sale. Well, obviously, once a rep works hard and generates 3 to 5 months worth of sales and then gets a 30-day notice, the courts are likely to get involved and say, hey, wait a minute here, this contract is out of line. Let's get the interests aligned, and let's make sure the rep is compensated for the opportunities that they've generated. And again, I think that's a reasonable approach for both supplier here, principal, and the rep. Yeah. Do understand the laws of the particular jurisdiction you're in. This too is something that's frequently laid out in the contract. It'll say that the laws of the country of France or Germany or UK or whatever might apply, and it's good to brush up and know from your local advisors what those rules are so you understand how that might impact the provisions. It is all about the commissionable orders here, and as we had said on one of the previous slides, looking to shipment is a common way to do that, but there might be other ways in your particular industry to try to identify what's the period of time or point and moment of time at which an order becomes commissionable. And again, just for emphasis purposes, there's typically a notice provision before there's a termination. Sometimes there's actually a right or opportunity on behalf of the rep to cure, or the principal here might lay out what the rep has to fix or correct to maintain the relationship. Then if the relationship is broken or terminated, then we've got a post-termination commission period. And again, that should be fair and negotiated between the parties as to what rep commission payments will be paid to compensate for the rep for the sales that are generated for the principal. Now we're heading into this boilerplate section I had mentioned at the outset. So there are 3 or 4 things that are kind of sleepers buried toward the back of the contract, but they can have a lot of meaning in certain situations. And just for clarity purposes, given the internet and everything like that, we do think it's just very, very important to have contract changes be documented or required to be in writing. If we don't have that, it's very difficult to prove conversations that happened orally, obviously, between parties and know what they said. So requirement that amendments or changes to the contract be in writing is very, very helpful and avoids these disputes of this oral, past practice, those kinds of problems that might arise. Survivability is also important. The manufacturer will look at that in terms of making sure they understand how long the duty of loyalty is maintained. Some provisions are going to be enforceable even if the contract is reviewed by a judge and portions of those are stricken. Those provisions might carry on. And again, beyond the duty of loyalty, there might be confidentiality, non-compete, other provisions in there that might survive this. It also applies to this indemnification provision. A rep might sell product in 2014, but there might not be a problem with that until 2017. So we generally want the indemnification requirements of both parties to survive the contract for another term of years, say another 3 to 5 years, or whenever an incident might arise in the field with respect to a product liability problem, as an example. Waiver is another one of these boilerplate provisions. It doesn't seem like much, but again, it can have real meaning. We just want to emphasize here that someone's not acting doesn't necessarily mean there's a waiver. We're trying to maintain the claims and rights of both parties here, and just because someone didn't act or couldn't act or was busy on another business venture or busy with another supplier or another customer opportunity doesn't mean that the contract provisions are going to change. And so it's a good mutual protection, for both parties. Assignment provisions, we're in an age where companies buy and sell themselves, on average every 3 to 5 to 7 years. So very important for both sides to know whether the rep contracts are assignable. Typically, a rep can't assign the contract to another rep because the manufacturer or principal here doesn't know the capabilities and the propensities of that other agency. And similarly here, we don't see situations frequently where the principal or manufacturer can assign the contract. And so typically there are mutual non-assignment provisions, but each side, of course, in writing can agree to an assignment one way or another. Notices are very important here too. So to permit email or electronic communication, that's a helpful thing. Having the contact information of who exactly, what parties will be contacted in case there's something that needs to be communicated under the contract is very, very helpful. Just makes it easier for everybody to proceed because they can point to that contact information. On the dispute resolution side, yes, there is a lot of litigation. There's a whole industry in terms of litigating commission claims one way or another. It's very, very helpful to get the parties talking. So to have contract provisions that require some arbitration or mediation, some negotiation of the dispute, understanding where that arbitration is going to be held, whether it's in the UK or some other country, and understand what the fee allocation is in case someone loses one way or another. What the fees relate to is really the legal fees associated with getting the commissions paid. And if one party is held to be the winner, let's say, of the particular lawsuit, sometimes there's an allocation of the legal fees associated with that. But good to lay that out in the contract. Also check with the rules and laws of your local jurisdiction. So with that, that's really the wrap-up, or this is the wrap-up then of the important provisions I've got in terms of rep contracts. Just to play it back a little bit again, big picture, the rep's value is the relationship they have with the underlying customers. Big picture under the contract, the most important sections I really think are in the termination and post-termination commission provisions. If you spend some time addressing those, you're going to have a good contract in place. And we'd simply ask too, if there's one provision that kind of struck you or was unusual today, if you could let us know what that might be, and any suggestions for improvement for today's presentation would be welcome as well. And I guess with that, I'd turn it back to the group or Laura to see if we've got any questions from anyone in the audience today. Thanks.
Thank you very much, Tom. I'd like to open up the questions to everybody in chat. So if you'd like to go ahead and if you've got a question, you can type it in there. Tom's contact details are, let me just put it back to the first slide. Tom's contact details are here. If you've got any questions that you'd rather email him directly, please feel free to do so. As part of your Commission Crowd membership, you get some up to an hour of time with Tom to discuss any specific things in the contract that might be really pertinent to you. So please go ahead and do that. But it's open to questions now, and we'll maybe give it just a minute or two, and if not, then this will be recorded as well, so it'll be sent out to you, and you can refer back to it at any time. Really appreciate everybody's time today, and Tom, thank you so much for coming to speak to us about this. I think we've got one question just coming through.
Yeah, yep, I see it, Laura, thanks. One point I would make too is almost always these contracts are not drafted brand new. You know, there's always a couple of copies floating around by industry or otherwise, and those usually are pretty good places to start, but they need some help or improvement to them. There's a lot of what I would call deferred maintenance on the industry contracts, and so finding what you've got in your particular industry is really helpful, and then using that as a building block for your new contract with your new principal, you know, is a helpful way to go. So I just wanted to mention that as well. Yeah, I see we've still got somebody typing here, so yeah, hopefully we'll have a question soon. So. Mm-hmm.
Do you think you can tell the audience a little bit more about, I know that we're talking about contracts today, but what are the other types of services that a rep might need to contact you about?
Oh, yeah. Thank you, Laura. Yeah, we typically get involved in 3 or 4 main things with either manufacturers or manufacturers, reps, principals, or agents, that kind of thing. Of course, are the contracts. We talked about that today. Yes, of course, we get involved in commission disputes, again, on either side, either on the principal side or the rep side of things. Also very commonly, and just because of demographics, there are so many agents worldwide that are 50, 60 years old that are looking to sell their agencies. So we actually help them market the agencies and do the contracts or agreements associated with marketing their agencies onto the next generation. I would tell you probably 60, 70% of the time those agencies are typically sold to other reps within the agency itself. Sometimes they're merged with or transferred on to other competing agencies, and a little bit more infrequently they're sold back to the principal, to the manufacturer as well. So there are 3 or 4 ways to go about that, and we work very hard to do that in a tax-efficient manner. There are ways through planning to do that to really cut down the taxes, frankly, that the rep or the manufacturer might pay and get involved in that, you know, as well too. But thank you, Laura, yeah, for the opportunity. So good.
Thank you, Tom. And while we're waiting, can you tell me a little bit?
One of the things, oh, yeah, Laura, yeah.
Oh, my apologies.
Hmm?
Can you tell me a little bit about who generally raises the contract? Whose responsibility is that?
Sure. Yeah. Good question too. I think at least 80% of the time the supplier, the principal, will raise that contract issue. I will say 10-15% of the time we see no contract at all. It's simply oral, which I think is a little risky for both sides, although I would say probably slightly favors the rep. But I would say somewhat laughably, almost always these contracts have been drafted by some attorney who's fairly new on the job because no one thought this was a very important thing. So the contracts generally universally are pretty poor one way or another unless someone's had a good chance to do a good thorough review. I've worked with 2 or 3 multi-billion-dollar companies, and I'll just tell you straight out, it's embarrassing to see contracts from 30, 40 years ago. No one really looked at them, and they miss all sorts of provisions like intellectual property, carving out the rep's prior existing relationships, maintaining confidentiality of the product that's being sold. So it's kind of a blind spot. I'd say most reps generally just want to get paid their commissions, and then sadly, I'd say there's probably problems with commission payments 15% of the time, I would give as a statistic. So it is worth it for both parties to invest something on the front end. Yes, the supplier, the principal might say take it or leave it, although in most cases there's some back and forth that can be done under the contract. Most suppliers understand completely if they get to a new rep or rep agency that's got some real good leverage and customer opportunity that they need to negotiate some of these terms. So from a sense of fairness and the market strength that's perceived by the manufacturer, a good result I think can be had for both parties in those contracts. We do see, and I'll just say straight out, sometimes abusive situations where you've got a multi-billion-dollar manufacturer doesn't seem to care much about its salespeople. Everybody's subject to a 30-day notice provision, and then they can't understand why they can't keep any salespeople. As most of the reps on the line know, most reps get involved once there's a significant opportunity. If it's less than significant, from a principal or supplier standpoint, you kind of get what you pay for, as well. Okay, and I just saw, Laura, too, we've got the question. Just let me take a minute here to read through this, and I'll play it back, too. So the question is, can you give some good examples how principals can drive agents' activities levels and its incentives and minimum sales targets? So just to talk about that, too, and this has been a trend, actually, for also the last 5 or 10 years, the sophisticated principal now might be commissioning not so much on top-line sales, but more on margin. So one of the things the principal is doing here to get the interest aligned is to say, look, it's real easy for you to go sell $10 million worth of product by telling me I ought to reduce my price to $9 million, and what's the problem with that? Well, if instead you say, hey, wait a minute, I'll commission you on the $3 or $4 million worth of margin that goes along with that $10 million product sale. Now we've got the interests aligned. The same profit that's going to the principal is being generated by the rep. And so the rep and agent in that example might get a much higher commission level. They might get 15-20% of margin rather than 5% of sales. And so these incentives are laid out very much, again, by industry in terms of what those sales targets are. Minimum sales targets are frequently developed by looking at what all the other reps on behalf of the manufacturer or the principal are doing, and what's the opportunity in that particular territory. Also, there's a drill down into what are the opportunities within that territory, the prospects, those kinds of things, and then some budgeting is done one way or another. Another big issue is, what did you sell last year? So if in 2014 you sold $800,000 worth of product and the underlying customers seem to be growing as a business, well, then to set up a budget of $850,000 or $900,000 as a target for the next year, I would submit is not all that unreasonable. On the other hand, let's say you've been selling into the oil patch and all of your customers produce equipment that go into commodities that now worldwide are in a macroeconomic slowdown. You might have sold $100,000 worth of product last year and only have a $400,000 goal this year. So it's very specific to what's happening there, but those are some of the examples, one way or another. Another question we've got, I just wanted to play it back so everybody can hear it here. Are there certain especially important points in the contract to be aware of in the case of a European sales agent that would sell for a U.S. supplier? And I would say generally in the U.S., we've got pretty good and sophisticated laws, when it comes to protecting agents and reps, and so both the principal and the agent should know and understand that. I would say it's very critical to drill down into the state law there of the location where the manufacturer is, especially if the contract relates to that. For the benefit of the reps here, typically those provisions in the United States would be double damages plus attorney's fees, and so you as an agent would be entitled to collect those, and the U.S. manufacturer should be where you understand those provisions. And it kind of doesn't matter if we're selling into the Far East, Europe, those kinds of things. Typically those laws would apply. It is, if you're a European agent, worth looking or understanding at the laws of the jurisdictions that you're selling in. You may or may not see some even better protections there. And again, it's very important for the principal to understand what those local protections are. But let's just go big picture to address the issue. It's all about, did the agent generate that order for $400,000? Did the principal, the manufacturer, the supplier get the benefit and the profit that came from that order? Well, then it's really hard for the manufacturer to argue that the commission can't be paid. In fact, I will tell a manufacturing client, pay the commission. The rep generated the order. Let's get him or her paid in that situation. But on the other hand, hey rep, if you really weren't all that involved tangentially, you're just named in the territory, but you didn't have anything to do with the sale, well then be careful there. Some of that compensation might be to support some of your other pioneering efforts, or you could be at risk here because you haven't been directly involved in the commissionable order there. So those are a few pointers in terms of the question, in terms of dealing with U.S. manufacturers, which I'm hoping would be relatively favorable and get you good traction in Europe. One I don't know that I've seen it much in Europe yet, although I frankly haven't been that involved in it. One big trend that people should be aware of is it got very, very common in the last few years for foreign suppliers to ask the rep to be their exclusive sales agent for North America, the United States. Similarly here, if I'm a manufacturer in Detroit or Michigan, and I'm just penetrating Germany for the very first time, not unusual at all for the rep in Germany then to be appointed the exclusive sales agent, get to carry the banner from a branding standpoint of that Michigan suppliers or principals products and really have exclusive control. The point the rep would make back to the Michigan supplier or principal is, hey, but for me, you'd have no sales otherwise. And the Michigan manufacturer is excited because but for the rep, they wouldn't have these sales that are going into Germany. So keep in mind, you can really have a storefront, a brand, and an image that's the forward-looking view of that underlying supplier from the state of Michigan here in the United States. And so I think that's a good way to go from creating economic value for both parties. So it's an exciting development. We've probably done a dozen of these in the United States, one or two internationally, and I think that's a good possibility, based on this question.
I just have another question, if it's okay.
Okay.
Can you hear me?
And Laura, I don't know if you want to wait a minute or two. I don't see anyone else, at least starting a question for now. But unless you've got some other thoughts to address, But happy to respond to other things if possible. Well, and I'm sure one thought I just had too. It is very important, and I'll have to add this to the outline for next time. I just personally believe for manufacturers and suppliers and their agents, it's critical for the agent to join some sort of association one way or another. This is how it's going to gain market knowledge and information. Most reps in these associations operate very independently. They might not be selling the same product, but there's a great commonality in terms of how agents go to market on behalf of their principals that I think a rep can learn from an association. Commission Crowd is just such an association, and I would also look to the local jurisdiction that any agent is in to see what rep associations might be out there. As a quick example, here in the United States, I think there are about 15 to 20 of them. They do break down by product lines. Let's say it might be original equipment supplies, it might be medical devices, might be food products. Here in the United States, we call that food brokerage for what it's worth. But to get involved in your local association and with Commission Crowd, I think is always a good idea for information purposes. It's going to get you all sorts of connections that you wouldn't have otherwise seen.
That's wonderful. Tom, I was wondering if you could touch on, from a rep's perspective, in terms of the prospecting stage, how much information, I know that legally in the US, they don't have to share any of the prospecting information other than reasonable updates and activity updates and things like that. But in terms of, do you have any guidance on sort of the mutually beneficial way of conducting a partnership like that?
Yeah, sure. Happy to do that. Reps could and should be appropriately guarding of their customer relationships. We all get that. The supplier and the principal gets that. Typically, what's done then, account by account designation, the principal, and this can be negotiated, might say, hey, here are 10 accounts in this particular territory. We just haven't been able to break into these. Would you go after these? You're entitled to full commission. The rep can come back right away and say, and there has to be a little bit of mutual trust, and it's, I don't think we have to write pages and pages of contract information to say, hey, look, guess what? I've got relationships with 2 or 3 of those folks. I want some special designation there because I've got that provision. I want a longer commission, once I get that in, a longer time frame for payment or some sort of other designation. Now, if 20 minutes after those names are conveyed, the rep is terminated, obviously we've got a challenge. Knock on wood, I've never seen that situation happen. The manufacturer and supplier and principal here is so excited about joining into that opportunity with those customers that the rep has. I think if the rep just carefully manages how it sets that information out. Then to speak more deeply to Laura's question, it's 3 years from now, and now the rep has relationships with 2 or 3 more customers that again would be brand new to the underlying principal. I think if you have a system that just says, hey, look, the rep has 2 weeks maybe to, the rep submits the information to the principal. The principal has 2 weeks to say, oh no, our engineers have been working on a product sale or a project for them, so no, we're not necessarily going to commission you. In that instance, I don't think the rep has lost much, and in most, I would say I'm back at 90% of the time, the principal is very excited. So some good give and take, relying on the relationships and trust between the 2 parties. Because I'll just tell you straight out, at the end of the day, everybody wants more sales. And so if there's a way to get that and a way to pay for that, I think most principals are excited about that opportunity. And I think if the rep just simply cautiously and stepwise sets out what those relationships are, I think that's best. I mean, one of the things I would not advise, and this is not legal advice, is laying out to the principal all of your customer relationships. Unless there was some other negotiation or some compensation that was going to come from that, reps should guard that. It's called intellectual property, or that secret, very, very carefully. So I think that can be done in measured ways in both places. Typically, principal is happy to brag about or list out all of the places that it has existing sales. And so if a rep sees that, oh, wait a minute, the supplier here, the principal is already in at XYZ manufacturing company, I won't call on them and waste my efforts. So there are ways in the give and take and exchange of information between the parties to manage that kind of thing. But good question, obviously, as well, too.
Yeah. Point, which was, I wonder if you could touch on if you've, I know certainly that Ryan's written about this in our blog, about reps who have had long-standing relationships with manufacturers or principals, and after exceeding expectations, so essentially getting fired for creating too much income. So at some point there's the principal's point of view that it's more expensive to have a rep than an internal sales team, so they fire all their reps. Is there any kind of legal representation or contractual arrangement of any kind that could help eliminate this kind of uncertainty?
Sure, yeah, happy to address that. It is the rep's lament or worry one way or another. If they get so successful or too successful, or they start making more than the underlying principal or the owner of the company has, they may be in a situation where they're at risk. Well, a couple of things there is, one is, it is really hard, but I would try to look at all of your contracts with your principals every year. And similarly, from a principal perspective, I recommend that the principals look at all those contracts annually. You've got the most leverage as a rep when you've got some of these bigger orders in process, but they're not necessarily landed yet. I've seen good reps in that situation say, hey, wait a minute here, I've worked 3, 5, 7, or 17 years with this particular manufacturer. Oops, I just noticed I've only got a 30-day notice and a 30-day post-termination commission period. That's not going to compensate me fairly. So I think it's okay for the rep to say in that instance, hey, look, let's update this contract because I've been generating sales for a long time and I plan on continuing to generate the sales for a long time. Let's expand the notice provision to 90 days. Let's expand the post-termination provision to 6 months or a year. But it does put the responsibility on the rep to realize that and do something about it. And I would say most good principals would recognize that as a means of supporting them. And the rep, I would just tell you all day long, both from a principal standpoint and a rep standpoint, has leverage to the extent they can move the business. So if the principal believes or understands that the rep itself could terminate the agreement and move the business someplace else because of this newfound opportunity, the rep now and the principal have a reason to contract with each other and make sure that the rep is being paid fairly. And again, I would recommend that the principal pay the rep fairly for those opportunities. Another good question, Laura, to try to address that. This is a hard one because it's a deferred maintenance kind of item, but that's why I just urge always these annual reviews of reps probably have on average 8 to 10 contracts with their underlying suppliers. Those ought to be reviewed, let's say, every November, just to set up a time frame before the beginning of the following year. And even on the manufacturing side, every manufacturer I've ever worked with had contracts that were 10, 15, 20 years old and clearly needed lots of update or improvement, and to cover this same issue that you're addressing, that the rep be treated fairly. If you don't do that, the warning is the same thing. Most jurisdictions would say the rep might get double damages plus legal fees if the rep isn't properly paid. So both parties have reason to address that issue. And I'm a strategist and an entrepreneur. It's all about driving value for both sides here. Want to make sure the principal gets the sales that it's looking for, and to me, the rep ought to be paid the commissions for that as well.
Well, that's really helpful. Thank you so much, Tom. I think we'll wrap it up now. It doesn't look like there's any other questions. But like I say, the email address for Tom is right there on the screen. Please feel free to send any questions that you might have. Also, within Commission Crowd in the application, if you go to your conversation section, we've added a legal pack in there. So there's all Tom's information, as well as a breakdown of typical things and what they typical aspects of a rep agreement or this kind of a contract, and you can get a better feel for that if you prefer to see it in writing there as well. Thank you so much, Tom. I really appreciate it.
Yeah, and thank you too, Laura. It was fun to do. Thanks.
Great. Bye, everybody. Thank you.
All right, we'll sign off. Thanks, Laura.